Hello, Jody.
Yeah,
Hey, sorry, I hope I didn't wake you.
well,
Well, I'm fixing to go back on the court case and I was in a small 3-minute break. I wanted to remind you to convert the church.
started working on it.
Honorable Justices of the Supreme Court Hear ye, hear ye, hear ye. This court from recess now in session.
Please be seated. Good morning. Welcome our guests this morning. Ask Mr. Doug Schema to please call the 10:30 docket.
Thank you. The 10:30 a.m. docket for Wednesday, May 17th, 2023 consists of two cases. First case, appeal number 125254, State of Kansas versus Devon T. Mitchell, Lyon County, briefs both sides.
Good morning, Your Honor. Kurt Kearns on behalf of Devon Mitchell. I'm present and ready for argument.
Good morning, Your Honors. Carissa Brinker on behalf of the state of Kansas, Lyon County, present and ready for argument.
Second case, appeal number 98433, State of Kansas versus Kenneth E. Frost, Johnson County, briefs both sides.
Morning, Your Honors. David Pachacano on behalf of Kenneth Frost. I am present and ready for argument.
And good morning, Your Honors. Kendall Kaut on behalf of plaintiff appellee, the state of Kansas, present and ready for argument.
Your Honor, that concludes our 10:30 docket.
Thank you, Mr. Schema. Call forward the council in 125254 state.
Kurt Kearns on behalf of Devon Mitchell, Your Honors. I'd ask for about 5 minutes of rebuttal time.
5 minutes of rebuttal. It's Brandon.
Well, good morning. If we knew of a citizen that was accused of a crime that went to a trial and was convicted, and we found clear evidence that that citizen did not speak English, all of us would say, well, that's not right. That's not consistent with due process. He should have an interpreter. That's well established. If we had somebody that was accused and went to trial and was convicted, and we had clear evidence that he had a hearing or she had a hearing disability, nobody would have a problem and say, listen, we need to see some kind of evidence that that person had some type of hearing assistance so that that person could be competent, if you will, in the course of that trial. What do we do in a situation where we have clear evidence that we have fluctuating competence, conditions that need to be put in place so that the citizen being tried has conditions that the psychiatrists and the people believe are necessary for he or she to be competent in order to stand trial? We've got an ebbing and flowing history in Kansas with regard to how we deal with mentally ill people. We've not done away with the insanity defense, but we now channel the insanity defense, as our United States Supreme Court puts it. We channel it to the judge. We channel it in making it a sentencing issue. Whereas before, we used to have the ability to say, hey, not guilty by reason of insanity. Look at how the mental health challenges this person has.
What evidence are you relying on that we could look at that shows your client wasn't competent at the time of the trial? I mean, there was concerns and assessment done, and all of the indications are from the evaluations of the professionals was that he was competent at the time of trial.
Justice, I think probably the best way to answer your question is to go right to the evaluation itself, which when you look at the language of it, and if I can just have a second, I'll pull it real quick. What does it say? Well, it says initially in the second paragraph that he lacks the ability to understand the consequences of his own behaviors. It goes on to talk about how he often fails to understand why he would even need to finish the assessment. at the bottom of the first page, it does not seem that Mr. Mitchell understands the consequences of his own behaviors and his own poor choices. It then goes on in the third paragraph on the second page to note that he did not appear to be trying to manipulate the assessment outcome. But he also, in the fifth paragraph of the last page, fails to understand the results of his own poor choices. And then in the concluding paragraph talks about how he does possess the ability to understand legal processes and participate in his own defense if given coaching and support. I imagine each one of us has the ability to understand advanced calculus if given a tutor for a long enough period of time.
But there
as
can
we,
be a difference between evaluating competency and evaluating behavioral problems, correct?
there's a definite distinction between those two. Yes, Your Honor.
And the assessment also says that there was a test, the MATCAT CA, an assessment to determine competency in 3 areas: ability to understand the court process, ability to reason legal strategies, and appreciation of his legal options. In completing this assessment, which was completed, the following results were obtained. In the area of understanding, he scored a 12 out of 16, indicating minimal impairment. In the area of reasoning, he scored a 10 out of 16, indicating mild impairment. In the area of appreciation, he scored a 12 out of 12, indicating no impairment. Assessment outcome was competent. And it also said that the defendant can quickly become uncooperative and combative. At the conclusion, he was coached by us to identify tools he could use to stay calm and cooperative when he returned to his cell. It was presented to Mr. Mitchell that he had a far better chance of reaching his placement goals if he was cooperative with his staff, not screaming or becoming combative. We followed up with staff at the end of the day to see how Mr. Mitchell behaved after that coaching, and he initially tried to walk to the exit door, but was otherwise cooperative. And then at the end, it says, while his behavioral response seems unpredictable and could be highly inappropriate, he does demonstrate the ability to control this. Ultimately, it does appear that Mr. Mitchell is competent to stand trial and or to participate adequately in his sentencing advocacy. So there are parts of the evaluation, including the assessment outcome, that indicate that he was competent in the view of this expert witness, correct?
Yes, with regard to that, and the same evaluator that's making that determination is also in the course of that evaluation discussing all of the coaching and support that they're being provided to get him to that state.
But you have the burden of proof to prove incompetency, correct?
Yes, Your Honor.
And there was no other evidence presented at the competency hearing except this report, correct?
Correct. And with regard to what the judge was aware of, we know that he was committed in 3 separate mental health organizations. There's no dispute about that. We also know he suffered from schizophrenia. There's no dispute about that. There was no dispute that he was, quote, mentally ill. There was no dispute about that either. In fact, what's interesting is that on the second page, the only evidence the court has was also a sentence that said a comprehensive psychological evaluation could present a much clearer picture of the struggles he has, i.e. KSA 2234-29. I mean, that's what the judge is actually reading at the time, is the evaluator saying, boy, it'd be nice if we had a comprehensive psychological evaluation that could present a much clearer picture of the struggles. Because gosh, it took us 2 days. It took us 2.5 hours when it normally takes an hour. So the court was in possession of undisputed evidence that we're dealing with a mentally ill individual, an undisputable evidence that we're dealing with somebody who's been committed at least 3 different times, and an undisputable evidence that with the proper coaching and with the proper support, we can get him to the competency level, which he is here now. The question is, was he competent at the time of trial?
In what way do you believe that the judge, the district judge who found him competent, abused his discretion?
Well, by first off, not reviewing, or at least not understanding the nuance of what the report was saying. And what the report was saying, when you read the whole thing, is we're dealing with a clearly mentally ill person who doesn't understand a whole lot of things. But if we get him right and we coach him right and we support him correctly, we can get him to a state of competency, which he is at the time we wrote this on April 4th of 132, without any examination into, well, what about during the trial when the lawyer brought up the concerns? What about at sentencing after this determination was made? So the abuse of discretion would be the ignoring of the totality of the facts as related in the report.
Criticize the judge for not ensuring that the defendant received coaching and support. But you had the burden of proof. So what did you bring forward any evidence that he was not coached or supported appropriately?
The proof, and I was a trial lawyer, I was just hired for the appeal, but the presentation was, here's the transcript. There isn't any of it. There's no evidence that he was ever coached. There's no evidence that he was supportive. We do have a statement from the trial lawyer indicating that he was acting nutty during the trial, and that's what brought this thing forward and to light. It's also, when the court talked about, his abuse of discretion and things like that, we have a statute that is designed to give judges power in mandatory minimum situations, like we used to when it used to be the insanity defense. We have the statute that says, you know what, if you send this guy off for an evaluation and Larnard says he is an appropriate candidate for treatment and an appropriate candidate when he's on his meds, he actually does pretty well. That's also in the report. But yet the judge was under the understanding he had no power to do anything other than give him the mandatory minimum 557 months. And when in reality, he had every discretionary ability to order an evaluation, to read that evaluation. And that's really what our concern is, Your Honors, is the lack of evaluation. The evaluation might very well come back and say, you know what? He was competent. We've looked into it. There's no problem here.
What's
But
your
we don't
evidence?
know.
What's your evidence that the judge did not understand he had the discretion to ask for an evaluation from Lauren?
Well, because he said so on the record that he had no discretion to sentence him to anything other than the sentence he gave. So if the court is of the understanding, I have no power to do anything other than the 46 years, sorry, but that's what the guidelines call for, then clearly he was not contemplating the full discretion he had in setting him for an individual evaluation pursuant to the statute.
Your client didn't ask for one.
My client did ask that he get evaluated at Larnard. And we have the Crosswinds counseling report stating that we'd get a lot better picture if we had such an evaluation. But as far as anyone saying, I would like an evaluation under, KSA 223429, no one said that.
Going back to the competency issue, isn't this really a sufficiency of the evidence?
If there was any sufficient evidence that any of this was attempted, then yes, but the proof is the lack of evidence in the record completely that anybody sought an evaluation, that anybody got an evaluation, when we have clear evidence in the record, in the report itself, of a very struggling individual who has serious mental health conditions with a history of multiple commitments in mental health facilities, with a conditional report that says he has the ability to be competent if given these things. And so when you have that situation where you're telling a judge, he's got the ability to do this if he does this, with zero evidence that was ever done, we're asking, if not for a reversal, for a remand to actually have that hearing so that we do know whether any steps were taken to protect that individual. So it's a dual part request for relief.
What's your authority for the claim that the state has an obligation to, or I don't know, the terms that've been thrown out as provide coaching or what have you? Once a determination of competency has been made, as you stated at the beginning, certainly competency can come in and out. But once that determination's been made and supported by substantial competent evidence, isn't it, I mean, and then it's not, was it ever raised again and ruled on again?
No, it wasn't raised again. The court essentially set it for sentencing and sentenced the client in accordance.
Well, when did the competency hearing happen?
In April, about a month before the sentencing, after
After.
trial, but prior to sentencing. So
That competency determination was made post-trial.
it was made post-trial, and in the motion itself, it pointed out problems during the course of trial that led the lawyer to believe he was not competent. In fact, when you go to the very facts of the case, they're really kind of undisputed. It's all on video, but the first statement out of my client's mouth about this horrible accident is, "Oh, hi, Dr. O, I'm off my meds." And then we have a report months later where people are testifying that when he's on his meds, he gets along pretty well. When he's off his meds, horrible things happen like this. To answer Justice Stiegel's question about what authority we have, well, we have a lot of authority with how I began this argument. We have authority that says sometimes there are conditions that we have to get people to make sure they have a competent representation. We give them a translator. That's to get them competent for
But
trial.
your argument is, as I understand it, that there was no substantial competent evidence to support the district court's ruling that the defendant was competent during trial because or it wasn't done until after trial and it's irrelevant essentially to what happened before.
Well, it is, our position is that the report was brought after trial, but the complaint from the lawyer was brought about during the course of the trial. And there was never any examination into, was he competent during the trial that the lawyer complained of?
Let me clarify here. Initially, pre-trial, there was a motion by defense counsel to determine kind of the notice of intent to determine mental disease or defect. And at the same time, kind of simultaneously, defense counsel had your client seen by some sort of psychologist or psychiatrist that produced a report to defense counsel. And based on that report, I guess, counsel withdrew the motion.
Dr. Jared Steffen, which kind of goes back to when he's on.
But so what obligation did the state or the court have at that point to pursue competency when that question was before the court, it was going, and then it was withdrawn?
Well, when we have a later evaluation done at the request of the lawyer that was reviewed by the judge that specifically.
You're talking about the post-trial evaluation.
Right, which basically says, hey, we never got a complete evaluation on this guy, and boy, it sure would be helpful if we had one. And we have a statute in place that discusses that exact procedure that went ignored. And then we had a judge that thought he had no power to do anything other than the minimum.
Well, actually, I'm going to push back a little bit on that because you're talking about the court saying he had no discretion. And this is the quote. The judge said at record 15, page 20, the statute specifically says he will not be eligible for parole prior to serving such mandatory minimum term of imprisonment. No other sentence shall be permitted. So the court really does not have a decision today on the length of the sentence in this case. The minimum sentence pursuant to the statute is 554 months. It's a life sentence. That refers to the sentence itself. It doesn't refer to the judge saying, I have no discretion to get an evaluation from Larned. It doesn't indicate he doesn't understand that, does it?
No, what I'm submitting to Your Honor is that he clearly wasn't thinking of a method by which he would not be bound by that statute when the statute exists.
Well, the statute exists for something that happens prior to the time the sentence is actually imposed, however, correct? So at the time the sentence is imposed, if there's not an evaluation done at Larned, then there is a sentence from which the court cannot deviate as to the minimums, correct?
That's true.
And when the judge has an evaluation, a competency evaluation that happens post-trial, the defendant still has the burden of proof to prove he is incompetent, correct? Because there's a presumption of competency.
Yes,
And the judge found based on the report that he was competent, correct?
based upon the last sentence of the report, yes.
Well, based on whatever he considered in his own mind after reading the report, and the report was admitted, the entire report was admitted as evidence, correct?
Yes,
And then the statute says that if this competency evaluation is done after the trial, you can look at what happened during the course of the trial, and if incompetency is found, then there's a mistrial declared, correct?
yes, sir.
But the defendant still has the burden to prove that during the trial, the defendant was incompetent, correct?
Yes,
And the only evidence presented was this report,
well,
correct?
respectfully, no. The only evidence presented is actually the lawyer's statements in the motion for the examination about how during the course of trial, he was asking questions indicating to him that he was not competent during the course of the trial. That combined with this report, which doesn't just say, you know, it does appear he's competent to stand trial, but it goes through his complete history of mental illness.
You're not saying that arguments of counsel are evidence, though, are you?
I'm not saying that it's evidence, but I'm saying it's a determination as to why you would read the entire report that's done and make a determination based upon the entirety of the report, which clearly says if he gets coaching and support, he has the ability to be competent. Now, that's not he's good to go. That's if he gets this done, then we have competence. We gave it to him here. Now he's good to go.
And the
It
judge,
doesn't, it's not a blanket, hey, he's just good to go for the rest of his life. Because as we can see in the history of this case, we have competency when he's on his meds, incompetency when he's off. Incompetency, he's wearing a pickle suit for crying out loud during the evaluation. You know, he's hearing voices, and then he wants a certain kind of Abilify to help him. So does Kansas recognize a conditional competence is another question. And we know we've cited a case outside this jurisdiction in Vermont that recognizes that there can be conditional competence. And then what do we do with it when we're faced with conditional competence? Should there at least be some kind of evidence somewhere that says we made a determination to fulfill those conditions, and here there's none?
and your burden was the preponderance of evidence, correct?
Yes, which we would rely on the report by Crosswinds, the full reading of that report to get you there. And I blew, I think, all my time. My apologies. Thank you. I reserve my arguments on my brief with regard to the other issues. Thank you.
Good morning, Your Honors. If mental health issues in the state of Kansas equaled incompetence, there would be a significant amount of people in the state of Kansas that are incompetent that have been found to be competent, as that is a huge issue. State of Kansas. This case is a case where the defendant had clear mental health problems. The state conceded that at sentencing because it was obvious and his record showed that he had mental health problems. However, Crosswinds found him to be competent. And that competency evaluation should be strongly considered. In reading the entire competency evaluation, it says that the defendant basically acts like a child, wants to control the consequences he has, and that he's manipulative in the system. He wanted to take Abilify for hallucinations, but Abilify was not a prescribed med for hallucinations. He wanted to take the Abilify, but he didn't want it in the dissolvable form. He wanted it in the form he wanted it.
I just ask you, on the report, the bottom line of it all, I mean, at least arguably is a conditional conclusion of competency if there's certain coaching and support provided for trial. So when you look at that, the conditions placed on the competency conclusion coupled with the absence of evidence of that coaching and support, why would that not be prima facie evidence, at least of incompetency? That's the argument that I understand your opposing counsel would be making.
Yes, and in Kansas, conditional competency is not recognized. And while it did say that he needed coaching and support, there were examples of coaching and support that he received from Crosswinds during his evaluation. He was basically given instructions. This is how you should act while you're in custody. You should act right. You shouldn't try and bend the rules. You shouldn't try and go against the rules. And he followed that. So that to the state would not be anything beyond what a defense attorney would be giving the defendant in his own advice and when he's discussing the case with the defendant. In this case, the defense attorney didn't file that motion for competency until after the defendant made a couple comments during trial. He wasn't acting nutty during trial. He made a couple comments to defense counsel that made defense counsel question that competency. However, defense counsel's statements are not evidence, and it's the competency evaluation and also the way the defendant acted during trial. Those are things that the court could take in consideration and could have taken into consideration and presumably would have taken into consideration in determining the competence. If he was acting a certain way during trial, if he was having outbursts, if he was having any issues, if he was actually acting nutty during trial, the court could have considered that. However, there were none of those issues during the trial, and the record doesn't reflect there were any of those issues.
Let's do a hypothetical that I always use myself. I'm on trial and I'm schizophrenic. And, you know, I mean, it seems to be undisputed that he hears voices. And you know, without divulging anything with attorney-client privilege, I'm hearing voices and I can't help. You know, the attorney says, well, what do you think of this witness, what they said? You know, and he's distracted because he's hearing voices. And that's not something that would show up in a transcript, right?
That is correct. It would not show up in the transcript. But the defense attorney, I think one of the key points is he didn't file this until after trial.
Well, that's what I'm saying. Well, so you're saying he should have filed it as soon as that you know what I see? I'm going to interrupt trial. I see that so you're hanging your hat on the fact of the timing of the request?
I think the timing is a very important factor to consider because the defense attorney did not stop trial. He did not.
Why isn't it better to wait until the end of trial?
Because if he had questions of competency, why would he want to continue the trial and continue going through the trial with an incompetent defendant, as a defendant needs to be competent in order to.
That reality though, saying, okay, you know, maybe he's competent. I'm going to wait and see how things turn. How long was the trial?
Trial was 2 days.
You know, so, you know, well, let me see how he does tomorrow. Maybe he's just having a bad day today, but he really understands and he can help me tomorrow, you know, on cross-examining or giving his opinion about what his defense should be or whatever. I mean, you know, the reality is that everybody agrees he's schizophrenic and has other kind of debilitating mental health conditions. And counsel saw that during trial and filed the motion, and it comes back and says, you know what, he does have all these issues, but he could be competent if he has the support. I forgot the 2 words. If given coaching and support.
And the evaluation doesn't describe what coaching and support is, but it does give the examples of what Crosswinds did in coaching, and they actually did use the
But
word.
what Crosswinds did, and this is, you know, based on my personal experience of understanding a mental illness. Crosswinds told him, this is how you should act. Okay, so no matter what's going on in your head, you're hearing voices, this is how you should act so that you don't get put in solitary, or so that you don't get injected with Thorazine, or so that you don't do this. So that coaching was how to act when you go back to custody, not can you understand and help, what's going on, and can you help your attorney? I mean, I think I see those two things as totally different.
There's nothing in the record that indicates that he did not receive coaching and support during trial. Defense attorneys are presumably going to have to give some sort of.
Presumably,
Some
So-
sort of, and there's nothing in the record that shows that Mr. Meyer did not give any coaching and support during trial. The record is devoid of that. And it was on the defendant to make that, it was the defendant's burden to show that he was incompetent. But even during trial, when the state rested, defense counsel still stated after he'd had consultation with the defendant had chosen not to testify and they decided not to present any evidence. And so he would have had some sort of consultation and had to discuss the matter with the defendant and had that contact with the defendant in order to make that determination. And the defendant's waiver of his right to testify, he would have had to have been something that the defense counsel would have been confident that he was willingly waiving this. And then there were no other signs of incompetence during trial. There
right,
were
but again, those are outward displays. When schizophrenia is not, there's conduct versus, what's going on in his head. It doesn't mean that just because there was no outward displays, lots of times courts find defendants incompetent to help, with their defense and participate in trial. When there's no outward display of aggression or, right?
Yes.
Can you remind, go ahead if you're,
Go ahead, Your Honor.
can you remind me what the time lapse was between the trial and this evaluation?
I believe it was a month or so. I believe defense counsel filed the motion a day or two after trial. However, Crosswinds was backed up, and so they were not able to get that evaluation until after. It was probably a month or so after, I believe, that he was able to get that competency evaluation done. And then we had the competency hearing in April, I believe it was. The competency evaluation, and then we had the sentencing about a month later. So it did take a period of time in order for the defendant to get his evaluation, just because of how Crosswinds had to work it and they weren't able to get that evaluation done in a timely manner.
Is there any evidence in the
Those-
record to show whether or not he was medicated during trial or medicated when he had the competency evaluation?
I don't believe. I do know that during, it was after trial, he'd indicated that he was not getting some of his meds.
That's in the record.
That I believe he did say that he wasn't getting one of his medications because of, some issue at the jail. The jail wasn't supplying that, whether it be for a financial reason or a prescription reason. But that was a medication that he, in his opinion, believed he needed. And the competency evaluation reflects that the defendant wanted to control stuff.
But it's just a simple question because I know the chief has a question
Well,
too.
well, my question was almost exactly that I hadn't seen anything that gave us information about whether medications might have changed from the time of trial to the time of the evaluation, or that there had been any therapeutic interventions during that time or anything of that nature. So I assume we have nothing in the record about that, or we would know that.
Yes, I do not recall seeing anything in the record that would indicate that anything had changed between the time of trial and the time of the competency evaluation.
Is there any evidence presented during the course of the trial to rebut the presumption of competency?
No.
Can I circle back to something you said earlier, but I think it relates to some of the questions you just answered. When you said Kansas doesn't recognize conditional competency, what does that mean?
So in Kansas, the way the statute is, either you're competent or you're incompetent to stand trial.
I think that is for all time.
I believe at least at this point, there is no case law that indicates that the conditional competency
So let
is.
me draw your attention to 22-3303, which is the long procedures that are set forth for when an individual is found to be incompetent. And that statute uses the phrase attaining competency, like I can't count how many times it's throughout the statute.
Yes.
Is that a synonym for conditional competency?
I don't believe it is because I think that that's after a finding of incompetency.
Yeah, but
has
how do
been
you,
made.
what does it mean to attain competency? What does it mean to move from a state of incompetency to a state of competency if it's not conditional, if it's not based on the conditions?
Yes, there are some conditions that would have to be met.
Yeah, like
such as-
medication.
Yes, such as
or-
medication or therapy or something like that, which is presumably what they would do.
And isn't that exactly what is meant by the term conditional competency? In other words, just put it in simple English, this person can be competent if they're on the right medication.
It could be interpreted that way. Yes, Your Honor.
Isn't that a cycle we frequently see, that someone will come back from audit or and be competent for a period of time, but then at some point, everybody says, oh, we may need another competency evaluation because there's a difference in behavior or whatever. Somebody may come and go for that competency process a number of times before the case.
Yes, throughout my experience, I have seen that multiple times where individuals do come back and become incompetent for various reasons.
And so is that the equivalent of conditional competency?
Like I told Justice Siegel, I believe it could be interpreted that way, that is conditional competency, because obviously a certain condition has to be met in order for that individual to attain competency. And that there are certain conditions that have to be met in order for any individual to attain competency.
Is there any evidence presented that he did coaching?
Your Honor.
Or any evidence presented that he did not receive support?
Could support mean, if given coaching and support, could support be construed to include being on the meds that he was supposed to be on? Because it's very troubling that, and I know this happens a lot. It's a huge concern is that when you are in custody, you don't get your meds. And and I guess the record is clear here that he wasn't.
I think support in one way could be for the meds, but Crosswinds also did speak a lot about the medications that he had been on and his choices that he had made to intentionally go off of those medications at various times throughout his entire time that he'd been treated from the time he was a juvenile.
Right, but I'm not talking, but the time, the question is, well, that poses a question. If you're in custody and your mental health, it's kind of a cycle, you're on your meds and you think, I'm fine, I'm gonna go off my meds. And then when you go off your meds, you're like, you don't even know enough to know that you should be on your meds. But let's say I decide when I'm in custody, I don't want to take my meds. And that makes me incompetent. Should that factor in whether I want to take my meds or not?
I think it should factor in because that's,
Really?
I think it should be.
And what in
a
the statute
factor.
supports that?
I don't believe there's anything in the statute itself that would support that necessarily. But that is something that could be factored in his decision-making. And,
But if he's incompetent, then he's incompetent to make decisions, right?
correct, Your Honor. But there's nothing in this record that indicates other than
Other than the fact that he wasn't taking wherever he was in custody wasn't giving him his meds because of price or
And that was one of the, that was only one thing that the defendant had brought up in court to,
right. So we don't even know how many
Judge.
other things.
so I don't know any of the other things, and we don't even know what medication it was. If that medication was a medication that was required for competency.
Should we
Um,
remand for an evidentiary hearing on that issue?
I don't believe so, Judge, because I think the record is clear. And there was sufficient evidence to support the court's finding that he was competent. Crosswinds in their report did not say that he needed to have any of these medications. They did give a list and a history of medications that he had been on and what he had refused to take, but when they did make their finding, they did not say he needs to have these medications in order to continue to maintain competency. They did say he needed coaching and support, which I would argue could be similar to what the defense attorney would be giving is in coaching and support during the trial and during the entire process. But they didn't specifically say he needs to have medication, he needs to have this medication in order to remain competent and in order to attain competency.
Was that evident, was there an opportunity for an evidentiary hearing where defense counsel could have called whoever did the evaluation and, explored the type of coaching support, what that meant, whether that was there?
We did have a specific competency hearing that defense counsel could have presented evidence at. He chose not to at that time. He chose to just both the state
argument.
and defense decided to just admit the Crosswinds report into the record.
Wrapping up.
Just that kind of how I started out, that if mental health problems in the state of Kansas equaled incompetence, there'd be a lot more incompetent people in the state of Kansas, which I believe is why we have the statutes we have and why we have evaluations and why courts can consider things beyond just the evaluation. They can consider their observations and their interactions with the defendant. And in this case, there had been numerous interactions that the court had with the defendant, with discussions with waiving his right to a jury trial. There were 2 of those, and the defendant and the court had numerous interactions. The court didn't have any concerns at that time that he brought up, and the defense attorney didn't have any concerns at that time throughout any of that either. Thank you, Your Honors.
I understand there's a concern about what the defense did and didn't do, what evidence did the defense present and what evidence did the defense not present. And what I heard my learned friend say was, we agreed at this hearing that we would both offer this report as the evidence. Almost a stipulation into what we're dealing with. And that report is disturbing. There's no way around it. When you read that report, we're dealing with an individual committed against his will on 3 separate occasions, who everybody agrees is schizophrenic, who 5 different times lacks the ability to understand. And then winds up with an overall, he possesses the ability to understand the legal process when he's showing up in a pickle suit for his own protection. He understands the ability, and he has the ability to understand the legal process if given the coaching and support, but there's no evidence of what that is. There was never any hearing on what that is. Did he ever get that? So the prima facie evidence presented by the defendants is the report itself, because it is a array of how mentally ill this young man is, with an ending that under these conditions, though, we're okay. Then with a finding that, well, we're okay, even though every one of us knows in dealing with this, that these things ebb and flow. If you're doing it with your meds and you're getting the coaching and you're getting the support, but nobody knows. So here we either go with, you know what, nobody knows, and it's tough for you, sorry, but your defense lawyer at the time didn't do what he should have done. because nobody really knows and you lose. Or we can read this report, recognize that it was a defense lawyer that brought up the issue, not the issue after the fact, but during the trial, I had these issues. And then here, read these reports where 4 different occasions throughout this report, they're talking about the things he does not understand, the things he does not get, how he suffers from audible hallucinations right then. But you know what? We're not even going to do the evaluation that the statute put in place as a due process replacement for the insanity defense. I mean, that's how it got upheld by our United States Supreme Court, is we're gonna, you know what, Kansas, you're okay taking away with the insanity defense.
You know,
because-
I just want to interrupt here. You know, I feel like that there is like some conflating going on between the insanity defense and competency to stand trial. Because those are two totally
Guilty.
separate. Okay,
Yes, Judge.
I just wanted to.
Guilty.
And at the competency hearing, the judge specifically asked, does counsel have any other evidence they wanted to present today? Correct?
Don't need it. We have this, Your Honor. That would be my response. if I
My
were asked that
question though is, isn't it correct that the judge asked specifically, does counsel have any other evidence they wanted to present today?
Yes, and he chose not to present any other evidence. That's a 1507 down the line, but he didn't apparently believe he needed anything beyond what we can read here in black and white to get you there. And what
But
we read
but
here.
in the black and white, there's nowhere in that report where the expert says, in my opinion, this person was not competent during the trial.
No, it's void as to whether or not. And that might be something we all might want to know too, because if we get a remanded hearing,
Isn't that the problem?
it's
That-
the
that
problem.
when your client bore the burden. No, and it's just not there.
Wouldn't that be impossible to prove though, a month after trial? For an expert to conclude who did not read the trial court transcripts, didn't, that he was incompetent to stand trial? How could you make a conclusion?
Yes, and can't. I
So
suppose.
how is
you
this
could-
not just a failure of proof? I mean, I guess we're asking the same question multiple different ways, but.
Well, because what we have is a request within this report for a comprehensive psychological evaluation that would present a much clearer picture. Because
What's the district court supposed to do? Let's put it
Easy.
this way, the district court is having a hearing. That the purpose of the hearing is to receive evidence. To make a fact determination on this most crucial question that's been raised by the defense through a motion. So what is the district court supposed to do when it says, I want to receive all the evidence? You have every opportunity, and counsel says, that's it, that's the evidence.
Yeah, I think to answer Justice Stiegel, he would say this. Well, Judge, KSA 223429 gives you the answer because it gives you the ability to go order a
That's a
complete cycle.
sentencing. That's the conflation we're talking about, isn't it? That statute has nothing to do with competency, does it?
It would allow the judge the ability to have a complete picture of his, according to this evaluation, a much clearer picture of the struggles that he has. Because these people had 2.5 hours over the course of 2 days. You recall he was unexplainably shutting down at one point while he was dressed up in his pickle suit. So the answer would be, well, there's a statute that's right on point that can give me a much clearer picture. I'll send this kid to Larned for a month or whatever, and they can get me a much bigger psychological report so that I can have a full understanding about what Crosswinds is telling me. So that would be our position. Thank you, Your Honors.
Thank you. Thank you to both counsel for your arguments this morning. The court will take this matter under advisement. Now call forward the attorneys in 98-433, State of Kansas versus Kenneth Frost. As counsel make their way forward, I will note that Justice Dandridge has just left the courtroom as she is recused in this appeal. That means she will not participate in today's hearing or in any part of the court process as we resolve this case, such as discussing the merits or writing or issuing the decision.
Or justices, I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
May it please the court, David Pachacon on behalf of Kenneth Frost, who is present. Justices, this case arises out of a failure of defense counsel to provide effective assistance as well as prosecutorial misconduct, both of which deprived Mr. Frost of a fair trial. Trial counsel was ineffective in two different ways. First of which, he failed to obtain some medical records that would have controverted statements of a state witness, and he failed to call a witness who would have testified that the mother of the victim made a statement regarding her desire to send Mr. Frost back to prison. This case, the state's case, and evidence was fairly limited to the statements of the child and the child's mother. While there were other witnesses that the state presented, those witnesses presented testimony surrounding what the child said to them. So the reason that this matters is that in order to find ineffective assistance as well as prosecutorial misconduct, we have to find that if these issues occurred, that they did prejudice the defendant. And obviously, the strength of the state's case goes into that consideration.
Let me tell you what I'm focused on. Justice, good or bad. Prejudice prong. I can hypothetically give you ineffective assistance of counsel on the medical records thing.
Correct.
Then the question is, what can you do with those medical records? Got them at trial. It seems to me the only two uses of that mother's testimony potentially impeach the child's testimony.
Correct.
Is there any other use?
Those would be the uses. And the reason why that matters is that the state focused a lot of its case on this encopresis, this soiling.
And I get that. I can also give you that this medical information would have been fairly damning credibility evidence against the mother's testimony that I've never had this before.
Right.
But it seems to me that just, so my but is, seems to me that, you know, the strength of the state's case in any of these kinds of cases, that child testimony. And I don't see the ability to use the medical records effective credibility against a child's testimony. The child's not going to remember what was happening in those early years. And the medical testimony was, 4 or 5 years ago and then stopped and all that. So it still seems to me that when the jury is facing the decision it has to make, it's basically looking at the credibility that it gives the child's testimony, which was pretty detailed and the way I'm taking it. So where am I wrong? I mean, what would you point me to show that use of the medical records with the child's cross-examination gets you over the finish line?
Well, it does somewhat impeach the child's testimony as well. As you stated, the child did also testify that he did not have these soiling incidents prior to. I concede that it's far less likely for a child to remember incidents that he had when he was 4 years old as it would be for the mother to remember. So this evidence does go further to impeaching the testimony of the mother. And I disagree humbly with the Court of Appeals. It stated that the evidence was so overwhelming in this case. There was evidence in the case that the child's story did differ from what he told the counselor, what he testified to at trial, and as well as the prelim testimony. There were discrepancies between what happened, how it happened, where it happened, who was home when it happened. While the jury could still hear this inconsistent testimony and find Mr. Frost guilty, this case was a credibility war, essentially. The state put on witnesses that testified that this happened, and the defense put on witnesses that testified that it didn't happen, or in the case of the expert testimony, why this incaprices would have been, could have been linked to something else. So, yes, Justice.
Another reason that I have been thinking about in terms of how this would impact the credibility of the child is that the child's statements that really the soiling here was perhaps on purpose, that he wanted to be gross and smelly in an effort to thwart any advances by Mr. Frost, which is different from what at least seems to have perhaps happened before, where there were involuntary situations.
Yes.
So, so does that change our view of how we look at the impact on the child's credibility?
It doesn't for me, and the reason for that is the defense theory was that the child's mother had a vendetta against Mr. Frost and had determined to send him back to prison, and that she then employed her child to form this story that would send Mr. Frost back to prison. So in saying that these incidents were different from the prior incidents because they were intentional, it's bolstered by the fact that she also testified that this had never happened before. This happened while Mr. Frost was present because it was intentional to keep him away. But in reality, it had happened before, which goes to the credibility of the fact that, or the possibility that it wasn't related to anything to do with Mr. Frost, that it could have been related to the hectic life that this child had lived. There was testimony regarding mother having different boyfriends in and out, unstable homes, and there was expert testimony on both sides where that the incaprices could have been caused by that anxiety of this hectic life. So when the testimony was that this never happened before and that it was only happening intentionally to keep Mr. Frost away, then that credibility of that testimony is controverted by these medical records that could have shown, well, you said this happened intentionally, but it never happened before, and that's the only reason it happened. But it's actually true that you had seen a medical professional for this prior to ever meeting Mr. Frost.
Do the education records, is that part of the claim as well? The milk allergy, and how does that
That was
blend
part
in with the medical record?
That was part of the medical record, that there was a request to be put into the school, that there was a potential that he was soiling himself due to a milk allergy, and food allergies or allergies in general was part of the testimony of the experts as well.
Over to the ineffective assistance of counsel on confronting the mother with these statements that she made, threatening statements. I got to admit, I'm having real trouble thinking that it's ineffective assistance to not ask the mother, did you ever say that you wanted to send the defendant back to jail? Because it seems to me that opens up a box that defense counsel would not want to open.
Are you referring to the motion in limine?
Yeah.
Well, first off, the claim isn't that he failed to question the mother. It was that he failed to call a witness who would have testified that that statement was made. And sure, I think in most cases as defense counsel, we all would have filed a motion in limine, keeping past criminal record out of the trial testimony. But where counsel was ineffective, first off, at the 1507, he stated that had he known this evidence existed, he would have potentially used it because he even saw it as damning. And there was argument back and forth. He claimed that he wasn't aware of this testimony. However, his own investigator stated that he investigated and presented counsel with that. However, counsel is expected to get all of the information and evidence that they need
Sure,
before
but the
making.
line
those-
of inquiry here. Seems to me, how do you keep the state then from delving deeper into what do we mean by back to jail?
Well, and I agree. I agree that, you know, if defense wants to bring that line of testimony in, it opens up, you know, the state. However, that strategic trial decision that trial counsel made should have been based on that evidence. And he may very well have decided if our theory is that mother was making the story up to keep or to send Mr. Frost back to prison, then that value may override the desire to keep past criminal
So
history.
you're saying it's ineffective assistance of counsel not to know. Get to prejudice. Boy, nobody wants to answer that. Nobody wants to ask that question.
Well, and I agree. I mean, I think I think that he was prejudiced because it went strictly to the defense strategy, which pointed to the mother having the vendetta, which would have gone to her credibility, which provides that prejudice that, you know,
What was he in jail for previously?
I don't recall, but I
Would
don't.
that matter to the prejudice analysis?
I think it would. I think it would. Obviously, if he were in prison for a child sex crime, then obviously that wouldn't be good for a jury to hear.
What happens when there are factual questions that are relevant to a prejudice determination when the district court didn't even get to that problem?
Are you saying because this wasn't brought to the district
Well,
court?
Correct me if I'm wrong. My understanding is the district court's ruling was that counsel's performance was effective.
Correct.
So there's no ineffectiveness, and so no need to ask the prejudice question.
On that matter, yes, yeah. Yeah. Now, the Court of Appeals found, at least on the matter of the medical records, that he wasn't effective, just that no prejudice. Which, again, based on, they based that on believing that the state's evidence was so strong. Of course, we disagree with that. When the state's evidence is solely credibility of the witnesses, I don't believe that makes for such a strong trial record that there's no prejudice.
And on the prosecutorial error argument, the false dichotomy argument, does that error or the nature of that error impact the prejudicial force of the ineffective assistance? In other words, yeah, and if so, can you explain what your theory is?
Yes.
there?
My argument would be that all of these issues standing alone were prejudicial. However, even if you don't believe that standing alone they were prejudicial, they provided that cumulative error that those medical records that could have controverted the testimony, the statement of the mother that she was going to send him back to prison, the saying not to believe the defense witness because he was paid to testify, commenting multiple times that the child was believable and told the truth. All of those together planted that seed with the jury that made it to where it was impossible for Mr. Frost to have a fair trial.
All relate to credibility in a
Correct,
sense.
which was really the whole case. There was no physical evidence. There were no eyewitnesses. It was solely, do you believe this side or do you believe this side? So credibility is the whole case. And the prosecutor downplaying the credibility of the defense witness and propping up the credibility of his own witness was prejudicial.
More of a technical question, but since you got into the prosecutorial error, this trial occurred when we had when we talked about prosecutorial misconduct, not prosecutorial error, and applied a different test. So before Sherman, in other words, do you believe that in our analysis, we look to Sherman for our test? Or do we apply pre-Sherman case law?
I would say that we apply, I believe the case is Tosh, which applies, or I'm remembering correctly, but that we need to look at, whether it was, whether there was ill will, whether it was gross and flagrant, and whether there was harmless error. And I think the repeated nature of these statements, obviously, there was only one statement regarding the expert witness, but the multiple statements which the state acknowledges in its brief standing alone were improper, some of them anyway, the repeated nature of these statements make them gross and flagrant and show ill will. And again, I would argue that the record of the trial record doesn't show that the evidence was so strong that it was harmless error. Thank you.
Thanks.
May it please the court, Kendall Kaut for plaintiff appellee, the state of Kansas. We'll start with the medical records issue. As it pertains to prejudice under the Strickland standard, I think the easiest way to think about this is that there are really two theories at trial. Either the child is believable in what the child says, or as Mr. Minahan outlines in our brief, mother had a vendetta against Mr. Frost. And the challenge with the vendetta theory that they'd have to prove for prejudice is that vendetta theory just doesn't make a lot of sense. Mother decides years later, boyfriends later, that she wants to punish him. Both sides, including Mr. Frost, on his testimony, when cross-examined, admits that child did indeed have encopresis when he lived with him. So we know during that time period, there was encopresis. The challenge then is if there's encopresis then, and child says, I was intentionally doing it, as Justice Biles and as the Chief Justice have mentioned, that becomes very difficult then to understand how this theory operates. As Mr. Minahan points out in the brief as well, why would the mother choose to use the child as the vehicle for bringing this claim? She'd had a PFA before. She had claims against him. Why would she have the child get involved in this? And she would have known by then, child has encopresis, so that would be an issue brought up. Instead, there is consistency in the main thrust of what the child has testified to throughout the preliminary hearing and at the trial. He said there were two incidents that happened. Both occurred inside the home, and that is strong evidence to show that there was not prejudice in this case, and that was the theory.
In terms of I got a little confused about our procedural posture, and I had to put my head back into it because we had denied review on the petition for review several years ago, and then now we're back. But you don't get to argue first prong of Strickland when it comes to the medical records. There's ineffective assistance of counsel. Now all we're doing is arguing about whether there's a reasonable probability that the outcome would have been different had that ineffective assistance of counsel not occurred, correct?
Correct, Justice Biles. That presumes you reach the issue. I had not planned to discuss the procedural history today. As you mentioned, that really does require you to put your head back. I have a whole sheet about when were petitions for review granted, what were the orders. And so I'm sure it's easier for the court to sit down and look at that and make that determination. But I agree, if the substance is evaluated by this court, we have conceded that there was ineffective assistance of counsel under that first plank of Strickland. The Court of Appeals was correct that there was not a trial strategy behind choosing not to obtain those medical records. Trial counsel should have obtained the medical records, then could have made a trial strategy. So we've agreed that part is ineffective. We are just arguing the second plank, that there is no prejudice to the verdict under that Strickland standard that requires overturning the conviction for aggravated indecent liberties with a child.
More than one judge who's looked at this case has found both prongs to be there. Failure to get the medical records was sufficient credit. let's take Judge Leben's. What's your disagreement with the way Judge Leben looked? Same file and came.
Justice Biles, my disagreement with Judge Leben is that I think the majority of judges who have looked at this case have reached the right decision, and the majority of justices, including the Tenth Circuit Court of Appeals. I believe we have 5 judges or justices, including the District Court, the Court of Appeals back in 2009, I think it was, and then 2 of the 3 justices on the Tenth Circuit. I believe they're correct. As it pertains
Those two-
specifically,
If I can interrupt, but because you may want to wind this into your answer to him. 2 of the 3, the 2 judges in the Tenth Circuit on the majority said, we're reaching this because this is a deferential standard of review. If we were looking at this de novo, that might not be our outcome. So I don't know how much weight you can put on those 2 judges, if any. So anyway, with that, if you want to address that as you continue your answer.
I guess I'm getting at the idea. This is a close call. It's a high burden that the defendant has here. It's a close call, right?
so Justice Biles, I don't think it's a close call. I can respect if you believe it's a close call. And as Chief Justice Lukert mentions, because the AEDPA is the standard that's reviewed for those 10th Circuit jurists who are looking at that, that does make it a different standard. I think them saying, hey, if it were de novo, maybe differently, does provide a caveat. We include that in the brief. The reason I don't think it's a close call, though, and where I disagree with Judge Leben, getting back to the original basis for your question, Justice Biles, is that I think the vendetta theory is really what's so clear here. And I think we've clarified that more in our newest briefing than maybe we clarified it in our original briefings. And so I think that elucidates what we have here. That, look, the theory for not guilty is that the mother has either created a story or a vendetta, or the child in that first interview he has to please mother. And that vendetta theory just doesn't make sense. It really is 2 theories. Now, when we talk about prosecutorial error, I think eventually during this argument, there's a basis for saying that shouldn't be told to the jury. But I think for us, it's not a close call because that vendetta theory just doesn't make sense. And the child says it on both occasions. Now, I can respect Justice Biles if you do come down to the conclusion it's a close call, but that's why we think it's not.
It's more than a vendetta theory. The mother's accusations and her consistent testimony throughout that this encopresis didn't happen until the defendant came into my child's life. And that just isn't true. And so, well, one, I understand the vendetta theory, but it also goes to the heart of the case, doesn't it?
So Justice Rosen, I think talking about what did the child, and this is difficult, obviously, because it wasn't brought up. And so I understand that. But I think if we're in that hypothetical world, we're talking about when the child is 4 or 5 years old, having encopresis. And I think the distinction that the child says this time, it was an intentional act that I did, and Kenneth Frost acknowledging when child lived with us, he did have encopresis during that time frame, makes those distinctions paramount. I think as it pertains to your vendetta statement, though, that does get to the heart of it. Is that evidence of vendetta or is it not? And we think if that had been brought up, it would not have provided sufficient evidence for vendetta. Obviously, there is some hypothetical in that world, though, Justice Rosen.
Why wouldn't the statement about the mother's desire to send him back to jail be important in the context of a vendetta theory?
So Justice Stiegel, I think that when we look at the prejudice prongs under Strickland and we look at ineffective assistance of counsel, that's a very reasonable trial strategy to decide someone who's a criminal history C, maybe not the best idea to bring up.
Do you know why he was in prison or jail before?
I don't have the full list of criminal history, and so I don't know which
Doesn't
ones.
that matter in this particular case? In other words, I can certainly see it's a reasonable trial strategy if this individual had been incarcerated for a sex crime against a child previously. But if it's shoplifting or whatever, I'm not so sure that that prejudice argument carries very much weight.
Well, Justice Stiegel, even in that hypothetical, that would be an example of a crime where veracity would be at issue, and Kenneth Frost is testifying in the case. But we know he's a criminal history C from the PSI and the 240-month sentence that was imposed by the district court judge, which implies he does have a person felony, implies he has multiple felony convictions. And so that's a real risk for trial court to decide.
Why is that such a, I mean, if your whole theory of defense is mom framed me, basically, this is a made up allegation that is in furtherance of a vendetta.
So Justice Stiegel, I think it's within the Overton window for a trial counsel to say, we've got to go all in on the vendetta theory. Let's just let the jury potentially hear about all of our criminal history. But I also think it's well within the Overton window and reasonable trial strategy for a trial counsel to say, hey, we don't want them to go back and know all the times our client has had
It's not
convictions.
reasonable at all. If the defendant is saying, no, I'm being set up, but how is that reasonable?
Justice Stiegel, I think it's reasonable because the jury going back there, I mean, this is why we have 6455 analysis and why there are so many protections.
You're just saying that a person who happened to have served time in prison and then they're just sort of vulnerable to these vendetta claims because I can't even put on evidence of a vendetta because the jury's going to know I was in jail before.
I think it's a trial strategy at that point, Justice Stiegel. I think some could disagree. Some could say, hey, I think the best strategy would be not to put that on. But Phil Crawford testified at the
So,
hearing. This is why he did.
Let's just assume hypothetically that this was a vendetta. Then that doesn't look like good trial strategy at all. to
And if-
me. Does it?
So Justice Stiegel, if you decide, hey, it's a vendetta, there is a huge risk in that framework that that's a bad trial strategy. I think if the court wants to go the direction of saying, look, we think this was ineffective on that plank. I know I addressed prejudice under the other plank, but on top of that, Judge Ryan, when he looked at the motion for a new trial, pointed out Phil Crawford said he did not have this presented to him. The investigator said I did. And the judge said, I believe Phil Crawford on this, that Phil Crawford did not have this evidence. So even if the court does believe, Justice Stiegel, hey, you know what, vendetta is the all-in theory. You got to do everything you can to push it. This is a unique example where it is beneficial and the risk outweigh, or the reward outweighs the risk, excuse me.
Yeah, you would say affirm on the finding of no ineffectiveness as opposed to prejudice.
Well, Justice Stiegel, I would say both, but certainly I can get the gist that maybe that's a more persuasive argument for members of this court.
But how can it be, how can it be strategic when counsel didn't even know it was out there, or it's not based on a reasonable investigation? In other words, that there was no strategic decision made based on an adequate investigation, which would have revealed these statements of the mother, alleged statements of the mother.
Yes, Justice Wall, that requires getting into the hypothetical world, which is why it is difficult. Just to make sure I answered that part of the analysis, that's why I did it. But I think that speaks to why you shouldn't get to that level and just say, look, when Judge Ryan said Phil Crawford didn't have the info, now we can't get into the second part of that because it gets very hypothetical at that
Well,
point.
no, didn't mean to, no, but I mean, how can you even resolve the first issue, I guess, that of ineffectiveness and come to the conclusion that this was a strategic decision when that statement was never even considered by trial counsel?
We can't say it is a strategic decision subjectively, why he made those decisions. So when Phil Crawford gives the examples for the medical records, we can do that. And we've conceded, hey, that was ineffective, but we can't do that subjectively. But I think objectively, those would be good reasons, Justice Wall.
However, correct me if I'm wrong, Crawford testified he would have used it. Didn't he?
And Justice Stiegel, I believe he mentioned that. I'm trying to remember, all the various hearings we've had. I think that is correct.
And so if he's saying I would have used it, then and his team had the information, how is that not ineffective?
I think it's because of Judge Ryan's ruling, Justice Stiegel saying, look, Phil Crawford testified to this. If anything, I think it shows veracity on his part to say, if I knew, I'm telling you right now, I would have presented it.
He knew.
Well, that was the discrepancy here. His investigator testifies at that motion for new trial. I told Phil Crawford. Phil Crawford says that was never presented to me. And I don't think you
Does
can.
it matter? I mean, that's what I'm asking. Let's assume that both that the investigator knew and that the lawyer didn't know. Is that still ineffectiveness for the lawyer to not know crucial information that his team is aware of?
Justice Stiegel, I don't believe it is. I think the lawyer,
An associate attorney instead of an investigator.
I think it would depend on the relationship. There'd probably be a multitude of factors to look at in that hypothetical. I think as it pertains to this scenario, though, if your investigator doesn't tell you something, when you're busy during trial, you've got a lot of different strategies to look at. I don't think we then have to start looking at what does every investigator know, every piece of detail, and now 1507's become
The attorney should not be charged with knowledge of his own investigatory team.
Justice Stiegel, I don't think that the attorney should be held responsible for something he's not told. And in that instance, if one person knows it, I don't think everything your investigators know, you should be imputed on. So now every 1507 is bring everyone who's seen the case file, ask them what they know, and then line up, well, the attorney didn't know this. Does that change things? I think that's an infinitely regressive standard and one the court should reject.
Let me wrote a question to myself, and let me see how. Assume with me that I accept Justice Paul's argument that you can't argue trial strategy if the lawyer doesn't know about it. Jump that. Did you argue a lack of prejudice? Assuming that it was in counsel on that point. What's that argument? It almost seems to me like you ought to know what the answer is on the criminal record, because you would want to say, even if he'd have known, he wouldn't have used this because it's a crime that the state could have pounded the defendant on. You know what I'm saying? So my point is, did you make a prejudice argument? Because I can't remember. And if so, what is it? Assuming you've got ineffective assistance.
I believe we do, Justice Biles, within our brief under the discussion about how that would violate their own motion in limine. There is a mention that he was not prejudiced by that. Our argument proper on that point would be, if that is brought in, he is still not prejudiced by it because of all the risks it would entail to put forward that the defendant has a criminal background, is a criminal history C, and how that becomes unpredictable for him. Even if that's added in, though, we still believe the strength of the child consistently testifying, the incoprecus coming back, and that additional phone call years later by Kenneth Frost causing the child to have incoprecus, and that's the basis for mother first going to medical doctors, provides strong enough evidence that the jury still would have convicted and does not undermine confidence in the verdict enough under harmlessness. I can see I'm out of time. If there are any additional questions, I'd be happy to entertain those.
Thank you. Reserve 3 minutes.
May it please the court. Justice, the state talked about the vendetta theory and how that was the crux of the defense argument. And there was mention in the state's brief about Occam's razor and looking at the most likely outcome. However, that's not the standard in a criminal jury trial, to ask the jury to look at the most likely. That sounds more like a preponderance standard than a reasonable doubt standard. And the reason I bring that up is because that argument goes more towards why all of this was ineffective than anything. The state wants to argue that it doesn't matter because it's still more likely than not that Mr. Frost did this. And going back to the incoprecus argument that state argues that it was uncontroverted that this came back. However, he also talks about how it was intentional, and incoprecus by definition is unintentional. And the reason that matters and why these medical records would have mattered are that the state's witnesses claim that this was done intentional and it never happened before, where the evidence of the prior incoprecus would have shown that not only did it happen before, but it also controverts, and the jury can make the determination whether it controverts the testimony that it was happening intentionally, and whether that is more credible than the medical records. But
You just stated that the medical evidence is that incoprecus is involuntary. It's not a controlled.
that's what I read, that the
And-
incoprecus was an act. I'm sorry.
Yeah, was that in the record? Was that discussed during trial? Was that?
That I
Try
read.
to at least address the witnesses saying that he did it on purpose.
The testimony of Dr. Logan, and I believe also Ms. Coggins, who was the counselor who interviewed the child. If I recall correctly from the evidence, both of them stated that incoprecus is generally an involuntary action.
It's always, yeah, okay, thank you.
And again, that's why this record that showed that it happened before, that it was involuntary, that it was due to other factors, would have would have contradicted the statements that it didn't happen before, it had only happened because Mr. Frost was around. And I want to go back to the trial strategy argument of Mr. Crawford choosing not to or not choosing not to bring this testimony in because he claims that he didn't know it. As Justice Biles stated, it's impossible to make that strategic decision when you don't have all of the evidence. And Mr. Crawford testified at the 1507 that he didn't have it. His investigator stated that he did. And also as part of the Court of Appeals brief of the appellant, there was an exhibit, which was a letter written by Mr. Frost prior to the trial to Mr. Crawford, stating that this happened, that this evidence is out there. So to the point that not only was it ineffective to not call it, it was, if you believe that he wasn't aware, it's ineffective that the office who was tasked with giving Mr. Frost a vigorous trial defense wasn't together enough that the investigator and the trial attorney knew the same thing. I'm out of time. Seeing no other questions, I ask that you reverse the Court of Appeals and remand for a new trial. Thank you.
Thank you to both counsel. The court will take this matter under advisement. Court is in recess until 9 a.m. tomorrow morning.